23 CR 229 is now called the State of Texas versus Cedric Jerome Fontenot. That's you, sir?
Yes, sir.
Present with your attorney, Mr. Burbank, and the state's attorney. Does the defendant waive a formal reading of the indictment and the arraignment here? Can we proceed in summary?
He does in your mail, Your Honor.
In summary, this indictment alleges that on or about October 25th, 2022 in Jefferson County, Texas, you committed the second-degree felony of manslaughter by recklessly causing the death of an individual, namely Jonathan Allen Brody. Pick up the phone. God. The sign can't be any larger. Don't bring a phone. Everybody's got a phone, I know, but everybody turns it off like they should. And that's just ridiculous for it to bellow out like that. And it is further alleged in this very serious case that you operated a motor vehicle in an unsafe manner while using a cellular device and causing the motor vehicle to leave the road, cross over, and causing the motor vehicle to turn over and strike another motor vehicle operated by Mr. Drody. And thus, it is alleged that you used a deadly weapon, namely a motor vehicle, that was capable of causing serious bodily injury and death, and did cause that in the commission of this offense. Do you understand what you're charged with here, sir?
Yes, sir.
A second-degree felony means you face a term of not more than 20 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
So,
an agreement has been reached where you would be pleading guilty, placed on deferred or unadjudicated probation, which can be up to 10 years in length. Fine $750. There will be other terms and conditions of probation which are normal and customary for this type of offense. Is that your understanding of the agreement?
yes, sir.
If I follow this agreement, sir, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this charge, this second-degree felony of manslaughter, guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily, that is, on your own free will, and because you are guilty?
Yes, sir.
Show you what's marked as State's Exhibit 1. Did you sign that document voluntarily?
Yes, sir.
Did you understand it? Discuss it with your attorney?
Yes, sir.
Is everything true and correct here?
Yes, sir.
State's Exhibit 1 is tendered into evidence.
No objections.
Without objection, it's admitted. Among other things, this states that you are mentally competent to enter your guilty plea. It is freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of this crime and any lesser included offenses. You have given up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You were totally satisfied with the representation provided by your lawyer. All of this is true. It states, so help you God.
Yes, sir.
State's Exhibit 1 is made a part of the record for all purposes. And again, pre-sentence report is here by way.
We do, the family's here to do it, so we asked it to be.
Anything else anybody wants to add?
No, Your Honor.
If not, if nothing,
Sorry for what's happened.
we can understand when somebody is injured, seriously injured, or a life is taken, you don't have the ability to bring it back. And a sorry doesn't bring back the life that the people want back. I'm looking at the information that I have in this case file, and it shows that since 2012, you have been convicted of over 20 motor vehicle violations. speeding, no seatbelt, speeding, failing to drive in a single lane, speeding, no seatbelt, running a red light, no seatbelt, wrong color stoplight on your vehicle, no seatbelt, speeding equal to or greater than 10% above the posted, no seatbelt, no seatbelt, driving safety course. You've had at least 2 driving safety courses, I think, that you had to take, right?
Yes, sir.
Failing to drive in a single lane, a non-injury accident in 2012, a non-injury crash in 2016, and then this in 2022. 20 violations. Now, this is what I've had my whole life. I mean, and I'm not special. I'm not. It's not that hard to follow the rules. It's only a 4,000-pound missile that you're weaving through traffic in. A 4,000-pound missile, which has to be operated safely.
So,
Not only for yourself, but all the other people who rely on your safety. But over 20 years, since 2012, I mean, that's 13 years, 22. I'm just going to tell you, you look like, it appears here, you don't care about anybody else. Everybody else is just victim, a potential victim. My goodness, nobody in this room probably has that voluminous, irresponsible behavior shown in all these tickets, accidents, and then now someone's dead. You can add remorse to the equation all day long. You should have been sorry the first time you got a ticket in 2012. But you didn't, you've been making mistakes as quickly as anybody else, irresponsibly as anybody else I've ever seen in operating a motor vehicle, which means you don't care about others. That's not humane. That's not the way we all make it. We don't make a contract with each other, but it's kind of like that. We have a duty, even though we sign a dotted line, we have a duty to safely operate 4,000-pound missiles so that others aren't put in harm's way, as well as yourself and your family, which you just seem to irresponsibly couldn't have cared for at all. You just didn't care. And here you are. And then you got grieving people who can't bring their loved one back. And too often these are called accidents, which minimizes the irresponsible behavior. This, you can call it an accident all day long, but this was inevitable. Someone was going to get seriously hurt or killed, if they hadn't already been, by your irresponsibility. Anything to add by anybody? Okay, I'm going to follow this agreement. I'm going to find you have pleaded guilty voluntarily.
yes, sir.
You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty.
Yes, sir.
There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here that finds you guilty beyond a reasonable doubt. But the agreement provides that you would not be found guilty. You may be placed on deferred or unadjudicated probation for up to 10 years, and it will be for 10 years. There will be terms and conditions of probation which are normal and customary for this type of irresponsible behavior. You're going to be required to take a safe driving program course and pass that. There will be other terms and conditions of probation that are, there are no less than 35 of them here. But a lot of these aren't going to be applicable exactly to you because of the nature of this offense, but most of them will. I'm not through. When you put our creators, humans, in harm's way irresponsibly like this, you pay a price. Somebody died. as a condition of probation. I can sentence you to 6 months in the county jail, and I'm doing it. That's the most I can do. You think it's funny?
Yes,
Of all of this, and you're going to grin at me?
That's my thing.
You're going to think you think this is, it's a grin. I know what a grin is. I'm old enough to know what a grin is. You think this is funny, sir?
I'm not grinning,
That's,
sir.
it's a message. It's symbolic because we can't bring the life back. But you have been irresponsible for so long with a motor vehicle. It was inevitable. This was going to happen. And if you had a clean record, and this isn't an accident, you're indicted for that you pleaded guilty to recklessly causing the death of an individual. Recklessly, which as its definition under the law. Get it word for word. It's just, I see, all we do is deal with humans here. Humans, and it has to be, you have to deal with them fairly and responsibly with the folks. But also, you can't hurt humans, and you can't put them in harm's way irresponsibly. A person acts recklessly or is reckless with respect to circumstances surrounding his conduct or a result of his conduct when he is aware of but consciously disregards a substantial and unjustifiable risk that the circumstances exist or the result will occur. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the actor's standpoint. That definition is not an award. That's a cruel, unthinking, unappreciative act toward others that you put in harm's way. And look, here it is. Somebody has died. What this court tries to do is be fair and impartial, but when the result is the death of a human, the court is going to set the standard I've always set, and the price is high when you are responsible for the loss of a human being's life. And you're going to jail for 6 months, and it will not just be punishment for you, but a symbol for others that they face 6 months in jail, which is hardly fair for the eternal loss of life. You didn't intend to do this, and I'm sure it's a terrible thing to have to deal with. But my goodness, why didn't you fix this 22 violations ago? We wouldn't be up here. Family all upset. You're upset. We're all upset. Nobody, if we could have talked to you the moment before you got in that car and urged, something bad is going to happen down the road. Cedric, think about it. Be responsible. Another human being or yourself. We're going to lose a human here. You'd have done. I think you would have tried to do something responsibly and been more careful. That's what. There are only limited things the court has the power of, and it's not to bring back life. Wish I did. Too often that sort of thing happens here. But the court can try to act responsibly in the determination of the punishment, and putting you on deferred probation is what most people get in here who haven't caused the death, much less even physical harm to others. They get deferred for nonviolent acts for the most part. But this has its place. And I've always thought the DA's office acts responsibly in what they do, and they know more about this than I do. But this court feels like with deferred probation, this condition of probation needs to be added, which is serious. And I don't know, I'll give you an option too. You can serve it on weekends, or you can serve it day for day. If you're going to serve 180 days, you get 3 days credit per weekend. You can do that 60 weekends.
You want to do that?
Yes, sir.
Well, I can guarantee you that that's more punitive than day for day. That's what people say, but it gives you an opportunity to go out and work and try to pay some.
Is that Friday at 6, Judge?
Yes, on or before 6 o'clock p.m. each Friday. And look, he's placed on probation, and the one thing that's not here is any restitution.
That was all worked out in a civil case, Judge.
Is that right? Is anybody from the victim's family here? I know financial is not what y'all are. But did you get fair
That was never mentioned to us. We didn't know any kind of restitution from him. We didn't know nothing about. It was never mentioned to us.
No, but
The wife came in and talked to us before. He was married at the time, Judge. The wife came in, we dealt with all that. I talked to her.
Okay, you told me.
His,
My
his
son's
wife,
wife. We have no business with her.
I know that, but that was when I first came in and all that was through her.
Okay,
hold on.
Are y'all have anything in pocket?
Or you don't know?
no, we're not out anything in pocket. We are not doing it.
Because I can hold that condition open for further information if you feel like it's necessary. But
I would like that.
because
They need to understand this is not for pain and suffering or anything like that. That's civil stuff. This is
That,
for
yeah,
stuff that's out of pocket or anything that costs
Anything
you money.
there, civil or anything, I think that's all been resolved. Am I understanding?
look, I'm not going to put y'all under the gun here on this. If I'm going to hold this open to consider restitution if information is received, because it seems like the surviving people here are just the surviving relatives. I don't think you're thinking about that right now. You're thinking about other things.
I don't mind, Judge, if you want to hold it open, but
I'm going to hold up to see, give them a little bit of time to make sure that there isn't a restitution issue. Because generally those things get resolved in the non-criminal end of things. People have insurance. Do you have insurance at the time, sir? You have insurance?
He worked for a company that who was on the job at the time, so that was dealt with the end. And there was a letter sent out.
But I'm going to give y'all a few weeks to see if there's something that was not a T not crossed or an I not dotted.
Yes, sir.
Financially,
But-
so that the family can be recompensed properly, fairly.
Unfortunately, under the time that this accident occurred, the next of kin was his wife. And so we dealt with her.
Okay.
So
The wife was going to be the primary person who would be speaking for, but y'all let me know if there's something that was missed, please. And the court will do what it can under the law. When can you begin?
This Friday, Judge.
All right, so it will be on or before 6:00 p.m. each Friday, and then they release you Monday morning. And where are you working now, sir? You're not employed? No, sir.
He had home confinement. He does have a monitor which will be released and he'll be able to now go to work. He lives home with his mom.
All right. This when the loss of life is the subject matter, it's difficult for everybody.
there's no alcohol in the system at the time. If the judge worried about that, it was just caffeine. And
No,
stuff.
I was just, if
there's
there's
nothing
any
else.
other reason that may have been the cause of this that I need to deal with.
No, Your Honor, that was a lot of factors.
All right.
We're not something
All
to
right.
do with.
Then we're recess on that.